very good morning, afternoon, or evening to you, depending on where you are joining us from. My name is Natalie Yap, and it is my honor and privilege to be the moderator for this webinar on understanding international arbitration practice as the convergence of civil law and common law traditions. Together with the SIAC, JILA, and today's panelists, we welcome our viewers from around the world. Now, today's panelists include private practice lawyers from both civil and common law traditions, and representing the voice of the arbitration user, we have in our midst an in-house counsel. And so here are our panelists. First, we have Mr. Yoshimasa Furuta. He is a partner at Anderson Mori and Tomotsune in Tokyo. Yoshimasa is admitted as an attorney in Japan and New York, and he specializes in dispute resolution, including international arbitration. He is a fellow of the Chartered Institute of Arbitrators and an executive director of the Japan Association of Arbitrators. Next, we have Ms. Yuko Kanamaru. She is a partner at Mori Hamada and Matsumoto, Tokyo. She's admitted in Japan and New York and has represented clients in arbitrations conducted under various institutional rules, including the SIAC rules. She lectures in international commercial dispute resolution at Keio Law School in Tokyo as well. And then we have Ms. Wendy Lin, who is a partner in the commercial and corporate disputes and international arbitration practices at One Partnership in Singapore. She has an active practice in a wide array of high-value, multi-jurisdictional and complex disputes, both before the Singapore courts, as well as in arbitrations conducted under various arbitral rules. Wendy has been recommended for her dispute resolution and arbitration work by various legal publications and was selected as one of the foremost highly regarded litigation partners in the Asia-Pacific region under the age of 45 in the inaugural publication of Who's Who Legal Litigation. She is presently the co-chair of the Young SIAC Committee. Next up, we have Mr. Tomo Tateno. Tomo is an in-house counsel at Inpex, a Japanese oil and gas company, and he is currently seconded to an operating company of an LNG project. Prior to joining Inpex, Tomo was with the international arbitration team of Freshfields Bruckels Steringa. Last but absolutely not least, we have Ms. Melissa Thung. Mel is a partner of both the litigation dispute resolution practice and arbitration practice of Dentons Roddick in Singapore. Her practice covers a broad range of commercial litigation and arbitration, and her clients are from a diverse range of industry sectors, including energy, shipping, aviation, and construction. She regularly appears at all levels of the Singapore courts and has conducted arbitrations under the auspices of the SIAC, ICC, Singapore Institute of Architects, as well as ad hoc arbitration, including under the UNCITRAL rules. She also has experience sitting as an arbitrator and was one of the members of the inaugural Young SIAC Committee, serving 2 terms from 2014 to 2018, and she's also served on other arbitration committees. Now, before we proceed to the main event, a few words about myself. I'm a solicitor advocate of England and Wales, and I'm with the International Dispute Resolution team at Nishimura and Asahi in Tokyo. As a common law lawyer practicing in a civil law jurisdiction, in and amongst colleagues and clients who are steeped in civil law traditions, the differences between the common law and civil law mindsets and practices have become extremely apparent to me. So I thank the SIAC and JILA for this opportunity, where we will explore how these differences have been dealt with in international arbitration. As to the structure of this webinar, well, first we will say a few words about the issue, and then our panelists will provide a description of core practice in their respective jurisdictions. And finally, we will discuss how these practices have melded and developed in international arbitration practice. I believe it will be a very interesting discussion that we're going to have this afternoon. And so we have also a Q&A function which we are monitoring. So please do feel free to send us your questions as we go along. And we will do our very best to address all your queries. So first, if we can frame this issue, well, I imagine that the civil law common law divide does not actually come into play in a situation when you have all parties and all tribunal members from either civil law jurisdiction or purely a common law jurisdiction. It is where the parties in the tribunal are from both common law and civil law countries, where you get a potential concern as to the different practices. So maybe I can first ask our in-house counsel here, what is the concern? What is the concern when you have potentially different traditions which may influence the way arbitration proceedings are carried out?
Well, thanks, Natalie. I guess from a client perspective, there are various issues, but one glaring one I think a lot of people would agree to would be the issue of disclosure, or in our arbitration world, I think what we call the document production, as opposed to discovery, document production. So I think a lot of people coming from civil jurisdiction are well aware. I mean, civil law jurisdiction, it is very rare to have extensive document production procedure. And accordingly, as reflection to that, it is rare. So it is rare to have abundant set of a suite of privilege rules in those jurisdictions. For instance, in Japan, where I come from, there is no privilege rules under Japanese law. So if there's a mixture, of course, if there's a mixture of civil law lawyers and common law lawyers in practice, one would really question what is going to be the applicable privilege rules and the like. But I guess the short answer to that one, whether that's a concern, I guess the answer is yes and no. Yes, potentially that can be an issue, but I think the answer probably is, at least from my perspective, it's not a significant concern because, I mean, there are a lot of discussions going on, like, you might want to apply the most protected privilege rules, or, I mean, I think it is common really practice now, at least the arbitrations I was involved in, you would probably agree to an applicable privilege rule when you're setting out your terms of reference, if it's an ICC arbitration, CX or whatever, I mean, the first procedure or whatever. So you would probably be agreeing to a set of privilege rules. So I guess the short point is this: yes, it's a concern, but no, if you're aware of the differences, even from client perspective, it is not that significant concern. So I think this session today will be a good one because you would get to know the potential issues that are out there that you're supposed to be aware of when you're entering into any arbitration. So I am looking forward to hearing a lot of views from the panelists today as well.
Thank you very much. Thank you very much, Thomas, for your perspective on that. Maybe now we can actually look at what are the different practices in the common law and the civil law jurisdictions, so that we can possibly get a sense of where this concern comes from. So in order to do this, we can look at the core practices of Japan, a civil law country, and the core practices of Singapore, a common law country. So in exploring this, we've divided this into submissions, documentary evidence, witness evidence, and the trial procedure in court. So perhaps now I could invite Yuko to give us a short presentation on Japanese procedure.
Okay, thank you so much. Can you please put the slide on? Okay, can everybody see that? Okay, so this is just the cover, but I would like to explain a basic understanding of the procedure in the civil law jurisdiction. And going to the next page, I will explain the two parts. One is about submission, and then the second is documentary evidence. The first part is, of course, the submission, pleadings, or statement of case. So I would like to highlight four features here. The first one is about the description of the statements, how detailed it should be. And then the simple answer is quite detailed. So under the Japanese law, it is required to describe the facts necessary to identify the claims, and then concrete statements of the case. And so it is required to put everything in the submission at the first moment. So it means that in the complaint and then also in the answer. The second feature I would like to highlight is the supporting documents. Whether it is required or not, the answer is yes, it is required. So under the Japanese law, it is required to submit the material evidence together with the complaint and answer. And so without that submission, you are told to submit it by the court. Going to the next feature, next page, please. So the third point is the number of submissions. Actually, there is no restriction in the number of submissions. And so it totally depends on the complexity and the number of issues and strategies by the parties, and then also the ability of the counsels. And then the court tends to allow the parties to submit as long as it wants. That is the tendency. And so there are usually about 3 to 4 submissions by each side. But there are, of course, more than there are some cases where the parties make more than 15 submissions. And it is not necessarily the same in the number of submissions on each side. And so, for example, in some cases, the plaintiffs submit only 2, but the respondent, defendant submit maybe 4 or 5 submissions. That is quite usual. And then the last point I would like to highlight in the submissions here is about the legal authority. Under the Japanese law, as you know, Japan is a black law country. And so the court should be aware of which law should apply. And so it is not necessary to submit the legal authority together with your submission. But for example, if it is about the case about the following acts or following laws, regulations, of course you are required or requested to submit the same by the court. That is the usual rule. Okay, so going to next page, please. Going to the documentary evidence, as Tomo mentioned, here are some issues about the documentary evidence. There are 3 features. One is about disclosure obligation, and then relating to that, rules permitting withholding disclosure, and then the penalties for non-compliance with the court order. The first feature is disclosure obligation. It might sound a little bit unfamiliar to the people from the common law jurisdiction, but also in Japan, in common law, in civil law country, the parties all obligation to disclose the document in general, as a general rule. But there are some exceptions in the Code of Civil Procedure. And then that exception is a little bit wider than in the common law country. So stepping into the next feature 2, about the rules of permitting withholding disclosure. There are many exceptions. And then as Tomo explained already, we do not have a concept of privilege, but the privilege can be covered with other type of exceptions. For example, there is an exception about the document regarding which someone owes some confidential obligation to a third party that can be withheld from the disclosure. And then that can be covered, the document which the attorney or the counsel handles for the client with regard to that case. So that can be privilege thing. And then the privilege concept can be covered in that exception. The last feature in this part is about the penalty for non-compliance with a court order to disclose the document. There is a rule, and then the court may find the adverse party's allegations concerning the details of the said document to be true. And then sometimes the court may further find that the adverse party's allegation is to be true. And so those are the penalties for non-disclosure. So that's it from me. Sorry, I explained too much, but I will pass the mic to Natalie again. Thank you very much.
Thank you very much, Yuko. Thank you for your detailed explanation. And now I will ask Yoshimasa to continue and maybe talking about witness evidence and trial in Japan.
Thank you, Natalie. So could you please show my slide on screen? Okay, next slide, please. Thank you. So as Yuko just explained, in Japanese civil litigation, usually in the pleading stage, party would exchange their briefs multiple times, maybe 3 times, 4 times, or in some cases more than 10 times. And when they exchange legal briefs, court expect that brief accompany a supporting evidence, including witness statement, both by fact witness and expert witness. And under Japanese civil procedure, those witness statement is treated as a written evidence. And different from many of the common law jurisdictions, we have no hearsay rule in Japanese civil litigation. So witness statement can be treated as evidence, even though there is no cross-examination. But however, in general, judge will not trust witness statement. They would trust more concurrent evidence like contract document, meeting minutes, or contemporaneous email exchange between the parties. So due to those reasons, no witness examination required and a heavy weight on the concurrent evidences. Japanese judge tends to rule no live witness would be necessary to adjudicate the case. Next slide, please. So in the majority of Japanese civil cases, no witness will be called to testify. If you turn to the statistics by the Supreme Court, in the year 2018, witnesses were called in only 14.4% cases, meaning 3 cases out of 20 cases nationwide in all of the district court civil litigations. In addition, when the court decided to call live witness, the number of witnesses are quite limited. In those 14.4% cases where witnesses are called, the average number of witnesses are 2.7. Generally 1 third-party witness and a 2-party witness. So in civil litigation, even if court calls a witness, you would expect only 1 witness from the plaintiff, 1 witness from the defendant, and probably 1 third-party witness. That's it. Next slide, please. And witness will be examined in open courtroom, which is open to public. Different from the ordinary arbitration practice, there will be no oral opening statement. So court will immediately start witness examination. And this is a slight diversion from the traditional civil law country. In Japanese civil case, parties counsel were primarily in charge of examining the witness. So the party who calls a witness would conduct direct examination. The counsel for the other party will conduct cross-examination. After that, if judge has any additional question, he or she may ask supplementary question to the witness. And the time range for witness examination is quite short if we compare it with the international arbitration or common law civil cases. Usually, court would allocate less than 1 hour for each witness. including direct examination and cross-examination. So usually you would have 2 or 3 witnesses, and each witness requires only 1 hour. So evidentiary hearing in total requires, in general, 2 hours or 3 hours. So meaning that will be concluded within just 1 morning or 1 afternoon. And after the witness examination, party may file post-hearing briefs. So there will be no oral closing statement. Party would just file written post-hearing briefs. Next slide. It's just a contact information. So that's all for my presentation. Thank you.
Thank you very much, Yoshimasa. Before we move on to the common law comparison, are there any questions? Let me just have a look. I don't think there are. Okay, thank you. Now, perhaps we can move on to Melissa, please, who will talk about submissions and evidence.
Hi everyone. So I'll start first by addressing the points in the same order that Yuko-san did. So to start with, the pleadings and statement of case, essentially parties document submissions in a court case. I understand most of the attendees today are from the common law jurisdictions of Singapore and India. So you should be fairly familiar with the fact that under the common law court tradition, we file statements of claims, defenses, and then replies. Generally speaking, they are supposed to be a summary of the case, but because we are all lawyers, these summaries tend to get very detailed and long. A lot of the reasons are because all material facts need to be pleaded. Although evidence does not need to be pleaded, there's sometimes a bit of a blurred line between what is a material fact and what is evidence. And you do want to be very sure that you have pleaded all the necessary points that you need to win your case. The other requirement, of course, is that you need to plead full particulars of your claim so that the other party, as well as the court, will be able to fully understand the essence of the case that you are arguing. The further requirement, of course, is that you need to specifically admit or deny every single allegation brought by the other side. And if you do not do so, you'll be deemed to have admitted it. This therefore means that you would have to produce a pleading that's almost equivalent in length to the pleading which you are responding to, so that you address fully every single allegation that is made. One of the other important factors that parties preparing a pleading need to be aware of is that they can only succeed on a claim on matters which they have pleaded. They would not be able to succeed on a point that is not pleaded and which the other party does not have notice of. It would actually be a ground for appeal in such a case. So for all these reasons, similar to the civil law tradition, the common law pleadings tend to be fairly detailed as well. The big difference, however, is on the next point, which is whether supporting documents are required. As I just mentioned, we are not required to plead evidence, neither are we required to exhibit any documents to our pleadings. There are some specific types of claims which require documents to be submitted. For example, personal injury claims, in which case you would need to actually submit your medical reports as well as a statement of your special damages claim. But otherwise, there would be no documents usually accompanying a common law pleading. The small exception to this is if you do go to the state courts and you go by a simplified process for lesser value matters. So for such claims, you would go by a simplified process whereby upfront discovery is required and parties are required to file their list of documents along with their statement of claim. Apart from these limited situations, a common law plaintiff's pleading would just be a statement summary of his case. The third point would be the number of rounds of submissions. Yuko-san mentioned that in Japan, there can be any number of submissions, whereas in Singapore especially, and I think in a lot of other common law jurisdictions, there is a strict limit to the number of times you can file a pleading to the court. Usually, the plaintiff gets 2 times, the defendant gets 1. The plaintiff's being a statement of claim, as well as the reply, and in between, the defendant files its defense. If the defendant comes up with a counterclaim, the plaintiff's second submission would be a reply and defense to counterclaim. And there is a procedural rule and rules of court which says that there are no further rights to file further submissions without leave of court. So generally speaking, all civil proceedings in Singapore, in Singapore would comprise only these 3 pleading documents. It's very rare that the court would give parties leave to file rejoinders or any further documents. As for the matter of legal authorities, that is not something that by default would be included in pleadings. Our procedural rules provide that points of law may be pleaded, but there's no requirement that parties put forward all their legal arguments in there. Of course, there are few legal defenses which you do need to plead if you want to raise. For example, the defense of limitation. But apart from that, all you are required to do is plead the necessary material facts to run whatever legal defense you are planning to run. As an example, in a case of a claim in fraud, you would need to plead, for example, the fact of the representation, the fact that this representation is false, the fact that you relied on it and have then suffered a loss. But you do not need to actually say, I'm relying on XYZ case, and on the basis of this case, I have established a fraud claim. So that is, but of course, because you do need to plead all these material facts, most lawyers, when they look at your pleading, would realize the legal defenses and claims that you are running and would prepare their responsive submission accordingly. In the case of foreign law, in the common law tradition, this needs to be proved as a matter of fact and evidence. So just like any other material fact that needs to be pleaded, you would need to plead specifically the points of foreign law which you are relying on and be prepared to prove that with an expert witness the same way you would any other normal fact. And yeah, but quite apart from all of that, the big difference, of course, I think everybody knows, is that in the common law tradition, stare decisis is a key aspect of the way in which we approach the resolution of disputes. We look at judge-made law. So whether or not legal authorities are specifically mentioned or referred to in the pleadings, legal authorities do feature prominently in our subsequent submissions and legal submissions as the litigation goes by. So next part of my presentation deals with the issue of documentary evidence and how the common law Singapore court deals with documentary evidence. So one of the, this again is one of the key differences between the civil law and common law traditions. In the common law tradition, the very scary thing is that we have very extensive document disclosure requirements. In short, all parties to litigation will expect to have to disclose all documents which are relevant to the case that is in their possession, custody, or power. The 2 key points to note is, 1, the documents must be relevant. And relevance in this regard would be a reference to whatever is pleaded. Any claims made by a party, any responses made by the opposing party. So anything that is either supports or is adverse to your case, or supports or is adverse to someone else's case, is relevant. The criteria of possession, custody, and power is another important aspect. It includes documents not only in your immediate possession, but documents which you can obtain from someone else. There is some gray area, as to what that type of obligation extends to. Of course, if it's with your mother or father, you obviously need to get it back because they would assume that you have the power to get it back. But if you have to pay money to obtain this document, for example, getting specific information from the bank, there's a rule that prevents parties from having to undertake oppressive steps or pay a lot of money to obtain documents if it's not directly relevant to the issue in dispute. But otherwise, you can expect, and any party in litigation can expect, that they would need to basically disclose everything that they have ever come into contact with that is relevant to the case at hand, so that the court has the fullest possible information in order to determine the dispute fairly. Another important aspect which civil lawyers and civil parties may want to be aware of is that in addition to this extensive disclosure, general disclosure requirements, they can expect that a common law party that they may be dealing with in a litigation would try to obtain documents which may lead it to a train of inquiry. These are documents which are not directly relevant to support or be adverse to a certain case, but might lead to that party coming across information which could either support or be adverse to that party's case. So you can see that this actually brings the scope of disclosure yet another larger step wider than what than just the documents that support or adverse to the case. In addition to this, discovery obligations continue throughout the proceedings. So parties continue to be obliged to produce documents as and when it might come into their possession, custody, or power at any point in time during the proceedings, all the way up to judgment. So in the common law tradition, the discovery obligations are quite notoriously onerous and very difficult for parties who are not used to this discovery process to really address and be able to fully comply. And that's one of the biggest issues when you have parties coming from other jurisdictions coming to deal with a case locally and in any other common law jurisdiction. Of course, the good news is that there are protections for certain categories of documents. As I think, as has already been said, one of the things is that documents which are privileged are protected from disclosure. Our concept of privilege covers the usual suspects of legal advice privilege, litigation privilege, without prejudice privilege. There are also some common interest privilege, qualified privilege, which do not always come up, but may be relevant depending on the kind of case that you have. I think the general touchstone for our law on privilege is where it's a public interest element in protecting certain types of communications from disclosure. Of course, in the case of legal advice and litigation privilege, the public interest element is in ensuring that a party is able to be open and honest with his lawyer without fear that any potential admissions or confessions might see the light of day in court and prejudice his case. Just for completeness, generally commercial confidentiality or other lesser forms of protection are not valid reasons to protect documents from disclosure. Apart from our privilege rules, you would actually be expected to disclose pretty much everything else. It doesn't matter if you have a contract saying that this contract is commercially confidential, you're not allowed to disclose it to anybody. And I think most lawyers will be familiar with the fact that these commercial contracts typically have clauses which provide for confidentiality, save for the exception of requirements of disclosure by law or by court order. So that would be generally our law on disclosure. One of the other onerous aspects of disclosure in the common law tradition is the penalties for non-compliance. I think it's quite clear that to see that under the common law tradition, the judges would expect to see all relevant documents so that they are able to make their own decision as to whether certain things are relevant, not relevant, and they do not want a party to be able to hide certain pieces of evidence which they consider relevant from their consideration. So for that reason, we have some very strict rules regarding non-compliance with discovery orders. The worst case scenario in the case of a breach is for your entire claim to be struck out. But of course, usually the court does not make it a practice to impose substantial or substantive injustice on a party who has breached a procedural step. So what would happen is that the court would usually give the parties a chance to remedy the breach by making an unless order. And if the party still refuses to produce the documents that they are ordered to disclose, it is open to the court to impose the draconian sanction of a striking out. If a fair trial is not possible without the documents. Generally the court will try its best to continue to get a substantive decision, but the worst case scenario is for the entire matter to be thrown out of the court. Yeah, I think that concludes my presentation on the two aspects that Yuko-san dealt with. And I think I'll turn it over to Wendy now to deal with witnesses and the trial.
Thanks, Melissa. What I would try to do is to do a direct comparison with what Yoshimasa-san has done in respect of witness evidence and trial and hearing. I'm picking up on what Melissa says, we are required to respond to each point in the pleading. So I'm picking on that aspect of my training. I'm going to try to respond to each point raised by Yoshimasa-san and to compare that with how we do that in Singapore. So witness evidence. I understand in Japan, that's usually submitted with the written briefs. That's not the case in Singapore. Directions will be given for statements to be filed by the factual witnesses only after parties have completed the very extensive discovery which Melissa has described earlier. So what that means is that as a Singapore lawyer, as a common law lawyer, at the point when you are drafting your client's pleadings, as Melissa says, we're only required to plead the material facts. The trick is actually to try to plead that as general as possible so that you give your witnesses room to maneuver after you've seen all the documents that come out in the course of discovery. Because I think all of us have that experience that no matter what your clients tell you, sometimes they don't show you some documents or they forget about some documents which aren't great for your case. So the good thing is if you try to keep your statements very general in the beginning, when you see these bad documents in the course of discovery, your witnesses are still, in a sense, able to address them at a later stage when you file witness statements. That's a bit different from, I think, having to file the witness statements right from the start, because I think then there's less room for the witness, in a sense, to address documents which are bad, right? So that's a bit different in the common law, the civil common law, Singapore law system. The witness statements will be exchanged simultaneously. So there is, in that sense, less risk of you being able to tailor your evidence after you see the statements filed by the other side. That's on witness evidence. Then in terms of trial, right? Yoshimasa-san mentioned that it is very unusual. The general rule is that the witnesses do not have to appear in court to testify. So it's the opposite in Singapore. If you have submitted a witness statement or what we call an affidavit of evidence in chief, then you're expected to turn up in court to testify. Otherwise, your statement will not be admitted into evidence. There are some very limited exceptions. So for example, if the witness has fallen really ill or unfortunately is no longer around, then there may be exceptions for the statement to be admitted, even though the witness is not turning up to testify. But I think in our experience, generally, if the witness doesn't turn up to testify, even if the statement is admitted, the judges here tend to give less weight to those statements. How the process of trial takes place, again, in contrast to Japan, we have generally oral opening submissions from counsel representing the claimant or the plaintiff, as we call it, or the respondent or the defendant. In the past, I think some judges would say, well, let's take it that I've read your written opening, so I don't need to hear oral opening statements. The Singapore courts in the last couple of years have passed a practice direction where they encourage opening statements to be made not by lead counsel, but by assisting counsel. And so now judges tend to give the opportunity for the younger lawyer to be the one making the oral opening submissions. So that's the general rule. What happens after that is the claimant or the plaintiff's witnesses will be called. Because they would have all filed witness statements, the direct examination is very short, basically to get them to confirm the statements. And then they will be cross-examined by the other side's lawyer. In contrast with Japan, where usually you only expect your pain to be over in at most an hour, main witnesses can expect the pain to last for days, in some extreme cases, even weeks, right? And so that's again another huge difference between, I think, Japan and Singapore. Judges' involvement in examination or in questioning. I think we heard from Yoshimasa-san that the judges have a supplemental role in terms of asking questions. In Singapore, because we have an adversarial system, it's generally, the burden is on the other side's lawyer to ask all the questions. The judges only step in if the questions are unclear, for example, or there are too many propositions in one question. It's an extremely long question. The judge might step in to say, I think you should break that up or make that simpler. Judges also step in if there are objections raised by the other side's lawyer to a question posed. Or in, I think, some extreme cases where the witness is simply not answering, the judge might then step in to say, well, can you answer the question? Or the judge might take on the role of asking some limited questions. But generally, the judges will leave it to the lawyers to do it because it's an adversarial system. Then I think there is a possibility after the claimant's witnesses have been called that the respondent or the defendant would say, I'm not calling my witnesses because there is no case to answer. But that's rather extreme because it would mean that you are basically saying even taking the plaintiff's evidence at face value, they've not made out their case. So it's rather unusual and people tend not to elect to do that. So what happens after the claimant's witnesses go on is the respondent's witnesses will be called. And then same process, the other side's counsel will cross-examine. At the end of the entire hearing, and I heard Yoshimasa-san saying that usually evidence, it's only evidential hearing only takes one day at the most. In Singapore, a short trial is considered a trial that completes in a week. That's what we call a very short trial. So usually it's much longer than that, right? And at the end of that trial, this is possibly the only similarity within our systems, we would have written closing submissions. That's the general rule. In exceptional cases where it's nothing but factual disputes and relatively simple, we might just have oral closing submissions and no written submissions, but that's rather unusual. So generally written closing submissions. In complex cases, the judges will then say, after that, I want to hear oral closing submissions. And some judges can, it depends on each judge. Some judges might then call parties back after some time for deliberation where they will give oral grounds of decision and then wait to see if anyone appeals before they write. Some judges would not do that and they would deliberate and write a written judgment which just gets issued when they're ready. I hope I have done a full rebuttal of the points raised by Yoshimasa-san. And I think one point that wasn't touched on was expert witnesses. The procedure is pretty much the same. So you expect the expert witness to have to put in a written expert report and be available in court to testify as well. So Natalie, over to you.
Thank you so very much. That was extremely thorough. And now we really see the sharp edge of the difference between the two traditions. On one hand, we have no penalties for not providing evidence in the civil law on the Japanese side, and versus at the far end of the spectrum, striking out of a case in Singapore. We have a 1 hour cross-examination versus cross-examination for days and weeks. So yes. I have a number of questions that have been filtered through to me. And maybe we could deal with 1 or 2 of them now. And I think some of the other ones we're going to actually get to in the discussion point. So maybe if I take one of the questions for our Japanese colleagues here. The question is, what is the value of expert evidence in a civil jurisdiction? And if I just add to that, in Japan, is it usual for the court to appoint an expert? Maybe I could ask Furuta Sensei first.
So it depends on the issue. For example, in a medical practice cases, party oftentimes ask medical doctor to provide expert witness with a defendant committed some medical malpractice. Or if the valuation of the share of the unlisted companies at issue, oftentimes we would ask some accounting firm to conduct valuation of the value, fair value of the shares. In international arbitration, oftentimes party would appoint expert for quantum issue, valuation damages. It is quite rare in Japan. In Japanese litigation, party rarely appoint expert in quantum issue. And under Japanese procedure, it is theoretically possible for the court to appoint its own expert, but still it's rare. Oftentimes, the party would appoint their own expert, provide expert witness statement, and if necessary, cross-examine expert retained by the other party. That is Japanese court practice.
Thank you very much, Yoshimasa. Yuko, did you have anything to add to that?
No, everything was told by Furuta Sensei. I have nothing to add. But I do agree that it's really, really rare. And then actually I had a discussion with my colleagues a few days ago about the expert in damage in the Japanese court. And then we concluded that it's really rare, and then the court will not require or take into account their opinion. And so we decided not to take that one. So that is the usual practice in Japan.
Thank you. That's interesting. Any comments from any of our other panelists from their own experience about value of expert evidence? Wendy?
Well, yeah, I was going to say that I think in Singapore, it's again pretty much the opposite. So if there is an issue in dispute which requires expertise in a particular area, the judges will expect you to call an expert to testify in the area. And the expert will then have to turn up to be cross-examined on the matters raised in his report. One point of commonality is, again, it's not usual for a judge as well a court in Singapore to appoint its own expert. Generally, it's for the parties to appoint their experts, and then these experts will turn up to be questioned by counsel as well as possibly the judges.
Okay, thank you. I'm going to move to another question, which is to do with the burden of proof. And I'll try and paraphrase it as I go. As I understand it, the question is this: in common law civil disputes, i.e. non-criminal disputes, the burden of proof is usually the balance of probabilities. Whereas in Japan, this the question says, is it correct to say that the burden of proof is much higher, almost as close to the criminal level in common law? Perhaps we could start with our civil law colleagues, maybe Yoshimasa first.
Okay, thank you. In Japan, civil procedure is originally from Germany, and criminal procedure now originally from the United States. So in criminal case, the burden of proof is quite similar to common law. It's a beyond a reasonable doubt standard. In civil case, technically speaking, it's quite different from the common law jurisdiction. In my understanding, common law jurisdictions, they require usually preponderance of the proof. In Japan, in civil cases, we have a very famous Supreme Court judgment in 1970s, which defines the degree of burden of proof in civil cases, which says in civil case, you don't have to prove the matter with 100% scientific proof. However, it should be the quite high degree of proof that no ordinary person would consider any doubt about the proof. So literally speaking, Supreme Court requires something like 95%, 99% of proof in civil cases. In practice, however, it's not so high. In my own experience, it is something like 70% probability possibility or 80% possibility required in an ordinary civil litigation. But maybe you could have some different thought on that. You are on mute.
You're on mute, you go.
Sorry, I was just talking to myself. I'm sorry. I do not have any disagreement here. Yes, it's around maybe 80% is the fair valuation of the comment, I think, but it is not 50-50 or 51-49, but more than that, I think, and it is true, but not 90%. And so maybe 80% should be something out there.
Well, I suppose to bring this question into context of international arbitration, is it not the case that it's if it's a Japanese law governed contract, for example, and the dispute is one which applies Japanese law principles, then it doesn't matter, does it, or should it, whether it's in arbitration or in court? It should not the burden of proof be the same? Or what is your experience? I can ask one of the senseis to advise us. Maybe Furuta sensei?
Yes, so it would be quite an interesting point. Probably it's a main topic of this seminar. So because I'm originally trained under civil law tradition, so I tend to require, as Yuko said, 80% proof, even if I serve as arbitrator in international cases. So it could be too high for extension from the viewpoint of the common law lawyers. So when you choose arbitrator, maybe you should think about that. In my experience as a counsel or arbitrator, civil law arbitrator tend to be more inquisitory in the cases, tend to ask more substantive questions to the parties during the arbitration process. In contrast, common law arbitrator tend to ask no question to parties, just listen to what both parties said, and party would find out what arbitrator think only when they receive award in the end. So that could be very surprised. So to me, because I'm a civil law counsel, sometimes it's very uncomfortable to receive surprise award with arbitrator in the end.
Thank you very much. I think actually that brings us very, very wonderfully and neatly to the next point. Unless anybody had some burning points that they wanted to raise. I see Wendy leaning forward. No. Okay. The next point I was going to raise for discussion among the panel was selection of arbitrators. Now, as counsel, how do you take into account when you're considering your arbitrator candidates? Do you take into account the civil or the common law backgrounds as an indicator maybe of their likely mindsets or approaches to the conduct of the arbitration proceedings? And maybe I could start with Mel.
Hi. Yes, we would definitely consider their civil or common law background, but maybe not so much specifically whether they come from a civil law or common law jurisdiction, but certainly whether they are familiar with the governing law of the contract in question, which would obviously determine whether or not they are qualified in a civil law tradition or common law tradition. Of course, there are situations where there are different laws at play because it is international arbitration, in which case you might have to select between a number of different laws and a particular arbitrator. There aren't many arbitrators who are familiar with several different types of law. So you may have to then choose which law is more important for the arbitrator to be familiar with. There are also considerations as to whether the arbitrator has a certain background or experience in a particular industry to be able to understand, quite apart from the law, certain customs within that industry that might be relevant that will help him understand why your client acted the way he had done in a particular case. Of course, I think the point that Furita Sensei mentioned just now about how civil arbitrators tend to have a higher expectation of proof is a significant consideration. Of course, as lawyers, we always try to prepare the case to the best of our abilities, but it is helpful to know, based on the sufficiency of your client's case, just how far you might be able to get with a particular arbitrator. So a lot of that comes in at the preparation stage when you're determining whether or not we can win on a certain type of argument with a certain kind of evidence. And of course, if there's difficulty getting witnesses, you may want to get a civil law arbitrator who will be a little bit more inclined to focus on the documents, or maybe even order a documents-only arbitration.
Thank you. Maybe we can get a perspective from Yuko.
Yeah, I do agree. The civil law or common law is one of the aspect or element we should consider about in choosing the arbitrator, but that is not the only element we should consider about. And then more importantly, the tendency and then also the reputation of the arbitrator. And then also as Melly mentioned, whether he or she is really specialized in some area like construction or those kind of things is really more important, I believe. And then that, as Melissa already explained, the tendency of the action totally depends on the character of the arbitrator, not only about where she or he is qualified in. And so I think, all of those aspects should be included in our consideration, and then not only about the jurisdictional things.
Yes. Okay, that's interesting, and I think just to round off this conversation, maybe we could hear from Tomo from the in-house counsel perspective. Your views, please, on selection of arbitrators, whether it features in your consideration or not.
Well, first of all, Natalie, we would, of course, follow what our external counsel advises. So that is far most important bit. But if there is any consideration from an in-house perspective, of course, at the outset of the case, in-house counsel is supposed to be, theoretically, more closer to the documents, that relevant documents, or the witnesses relevant to the case. So if our counsel advises, this arbitrator has certain tendency in relation to document production, we would probably comment on that for the external counsels to take into account. Of course, if there's some tendency that admissibility of evidence, like, to what extent the witness has to be remote from the case, if there's that kind of tendency coming from that civil law, common law, or whatever background, then of course we would, articulate our concerns and ask our external counsel to take that into account as well.
Okay, thank you very much. I think some of the questions that we've been receiving, and thank you to our viewers for the questions that are coming in, but quite a few of them dovetail quite nicely with some of the points that we were going to raise anyway for discussion. And one of them has to do with cross-examination. Now, I think actually the main point has been dealt with, which is how is cross-examination done in civil and in common law jurisdictions. But perhaps we could have a discussion about international arbitration and how international arbitration deals with the examination of witnesses in a hearing. That's one part. And secondly, I think, which is also a question we've received, how do you in your respective jurisdictions deal with the preparation of witnesses? Perhaps I could start first with Wendy.
Yes. Right. So international arbitration, I think it's somewhere a nice mix between the civil and the common law traditions as we've heard today. So there is cross-examination of witnesses as well, usually longer than 1 hour, but it doesn't last for days and weeks. And we tend to work on the chess clock system, which is nice because I think people end up focusing the cross-examination on really the key areas in dispute. Instead of sometimes going a bit on a roving exploration to see if you can get something out of the witness. And if your arbitrators are from a civil law background, they may not be as patient if they don't feel that the question is directly relevant. So that's, I think, one of that's a slight difference between international arbitration and maybe the common law court practice. And in terms of witness preparation, it is usual for there to be witness preparation, certainly in Singapore, and I believe actually in most jurisdictions as well. Where we have to draw the line, of course, is we cannot coach the witness. The evidence has to be the witness's evidence. We can't be telling the witness what his or her evidence should be. So that's I think, in terms of professional conduct, that's where we have to draw the line, certainly from a Singapore law perspective.
Thank you. Yoshimasa, do you have something to contribute?
Right. Actually, to me, international arbitration practice today is more like a common law practice rather than civil law practice. So we should expect a longer time duration for cross-examination. And also cross-examination is quite very important in international arbitration. It's kind of a highlight in international arbitration practice. And witness preparation would be the issue for civil law lawyer. In Japan, as I said, we have some diversion from traditional civil law practice. So we would cross-examine witness. I mean, lawyer would cross-examine witness, and lawyers are allowed to prepare their own witnesses. However, in some civil jurisdictions like Germany or Switzerland, judge will have a primary role in examining a witness, and the lawyer are prohibited from preparing their witness. So if you have German lawyer or Swiss lawyer in international arbitration as a counsel, they would not expect the other party to prepare their witness. So there would be no, level field between parties. So the arbitrator must be careful to provide equal opportunity to both parties in terms of witness preparation in international arbitration.
Thank you. Maybe we can then direct this to Tomo as a as in-house counsel. When you have a situation where your colleagues are going to be called as witnesses, yes. How do you hold their hands through this process? Because of course it's an uncomfortable situation to be cross-examined.
Well, there are a lot of aspects, but from in-house perspective, it is really managing, like you say, managing the potential witnesses. And it's to a certain extent colored by, I suppose, the topic we're discussing about today, because if the advice from our external counsel is that, the tribunal would prefer having the witness being remote from the case or even isolated, no preparation at all, then we would have to find a way to do that. Because definitely if you're in an organization, you would be, be close to the case. I mean, if you're in the same division. So that's one aspect of concern for in-house counsel. Another one really is, what do you do if that potential witness resigns or retires? You know, for instance, shall the company have a witness retainer with the witness? Or shall we ask the law firm because the tribunal will prefer the witnesses to be more remote? And, you know, if we do have those witness retainers, another concern for in-house counsel will be, how much shall we pay as a retainer, of course, because, I mean, if the witness knows that he's valuable for the case, the reality is he will ask a lot as a remuneration. And then there'll be a question as to, you know, if we pay this much, will he be considered as a, you know, independent, isolated, remote, or, you know, fair witness, not tainted by the company? So as an in-house counsel, yes, I mean, unlike when I was practicing in Japan, those kind of considerations do come into play when I'm in arbitration cases.
Yes, thank you. Now, I'm conscious that we are running up into the last 10 minutes, and I do hope to all the people who have raised questions that some of the questions you have asked, and I know that there are really quite a lot of questions, thank you very much, but I hope we've managed to cover some of them in this discussion so far. But maybe I could ask some general questions which maybe will also address some of the ones that have not been covered yet. Now, one of the things that we've talked about is the way that submissions, the documentary evidence, and how these things are dealt with in your respective court jurisdictions. But how about your experience in arbitration? What are the norms? What are now the most common practices that you see in international arbitration? Maybe I can break this down to the submissions side of things. So if we could have a quick sort of overview, maybe from Melissa, what in your experience is the norm, the most usual practice for international arbitration when it comes to dealing with submissions? And then I will raise the same question to Yuko when it comes to documentary evidence.
Okay, so in brief, in international arbitration, I tend to see that parties require equality in submissions. They don't seem to respect what we regard in common law to be tried, which is that the proposing party has the right of final reply. So generally speaking, I do see that there are equal number of submissions from both the claimant side as well as the respondent side. The other thing is that we do have memorial style submissions at the start, which means we do not adhere to this common law tradition of pleadings without documents. Our submissions to arbitration, generally speaking, do include our documentary evidence. And that's actually what is covered in the SIAC rules as well. Parties can produce additional documents in our witness statements, but generally speaking, the expectation is that by the time you complete the filing of your pleadings, you would have most of the documents already disclosed. Of course, subject to whatever happens in the subsequent disclosures.
Thank you very much. When it comes to your experience, Yuko, maybe you can have a couple of minutes on what your experience is when it comes to international arbitration practice.
Yeah, thank you. In the international arbitration, I experience usually a memorial style. You know, the parties are limited to submit their submissions. And then one submission should include not only the pleadings, but also all the evidence together with the witness statement. That is the usual style. And then while I explain that in the Japanese court, it is required to submit the main or material evidence together with the pleadings at the scratch, we usually do not submit the witness statement at the first moment. And so it is really, burdensome for us to prepare everything at once and then submit everything together. But as Melissa said, we usually have some idea of the evidence together with the witness, who should be the witness. And so that is what we usually do. And then what we have to do is just, take time to prepare everything and then just, make a submission. So that is my experience.
Just
Yes,
one point to add, I think from a common law perspective in terms of document production, what is different, I think, international arbitration practice is a party is only expected at the first instance to produce documents you are relying on. So you're not required to produce all relevant documents in discovery as you are required to do in the court system, where you even have to produce documents that are potentially adverse to you. So you don't have to do that in international arbitration, which I found to be an interesting and refreshing and strategic sort of thing that you can actually adopt in international arbitration. So only use the documents that are good for you and wait to see if your opposing side actually makes specific requests for documents which might be adverse to your client's case.
yes, yes. That is an interesting feature for a common law lawyer. Yes. Okay, I'm told we have just 5 minutes left, so I'm going to just ask a question which is maybe more of a general question than strictly about international arbitration practice, but it is this. Do parties tend to settle as much in civil law jurisdictions as in common law jurisdictions? And maybe I can refer this to Yoshimasa first.
Thank you. Well, actually, for the settlement, I think both in civil law and common law, party is very eager to settle. For example, in common law jurisdictions like United States, the court oftentimes encourages both parties to go to mediation. And but the difference is in civil country, judge will encourage settlement, and during the settlement discussion, judge himself or herself act as a mediator. And if settlement discussion fails, then that judge will decide the case. But that scenario will never happen in common law country. In common law country, judge oftentimes encourage both parties to settle, but in mediation process, mediation will be administered by mediator, who is a different person from the judge. So that tradition also affects me. So even if I act as an arbitrator, I oftentimes struggle against the temptation to encourage both parties to settle or recommend some settlement proposal to both parties. So party will settle either in civil country or common law country, but the settlement process would be quite different between civil litigation and common law litigation.
And maybe a perspective from Wendy about settlement.
Well, I am not entirely sure that in law systems, people tend to settle that much, not in my experience anyway. I think for the very complex cases or high value cases, actually they tend not to settle. I mean, please do try, and if it makes commercial sense, people do try, but sometimes the difference is just so wide, they end up not settling. And from my own experience, I don't think there is a divide between civil law and common law. I think all businessmen wish to be commercial if a deal can be struck, if there can be a win-win situation. It's just sometimes the cases, people are so far apart. Sometimes even when you go to an experienced mediator, they can't find a solution for the parties.
Thank you very much. And maybe we can get a perspective from Tomo. You've seen it all. You've been in private practice, you've been in in-house counsel, and maybe you can tell us what you think about settlement and your views on whether or not it happens more or less in certain jurisdictions.
Well, I tend to agree with everything just Wendy just said. It really depends on circumstances, and it appears so far to me that civil law, common law distinction is irrelevant to whether we're going to settle or not. It's just depends on the case and nationality, I'd say.
Okay, thank you. I think we've just about come to the end of our session. So I think just to wrap up, maybe the one takeaway from this webinar is that while there are very stark differences on both sides of common law and civil law practice, in reality, what happens in international arbitration is that a lot of these differences get smoothed down, and I think that from the user's experience and from counsel's experience, we do see that quite a happy way out is often achievable. So once again, on behalf of the SIAC and JILA and the panelists, thank you to our viewers. Thank you for the questions that have been submitted. I'm afraid we didn't manage to get to all of them, but we thank you for your attention.
Thank you.